acquitted conduct can also only be used when it is also convicted conduct. And if I may, I can point to some hypothetical examples.
Before we do that, let me just focus on the Mann Act for 1 second, and I hope it will inform this discussion. So the Mann Act is indicted to say that the transport was of either, as to count 3, Ventura, or the escorts, and as to count 5, Jane Doe or the escorts. But at trial, the government's theory was that count 3 is violated and count 5 is violated by transportation of escorts to engage with Ventura and Doe, right? So it's not Ventura and Doe that are transported for those convictions, isn't that right? Or because that's what the government's closing argument is talking about, transporting the escorts.
Yes.
Well, mostly. So is it do you believe that either the transportation of Ventura or Doe or the transport of the escorts could be the basis of the jury's conviction on 3 and 5?
I think it was that if you look at the charts, the focus is on the escorts for sure.
Well, I was looking at the closing arguments.
Yeah.
The government's closing argument.
I think that's right.
So if the theory advanced at trial is that the escorts are the ones being transported, but we're referring to count 3 as the Ventura count and count 5 as the Jane Doe count because that's the person who was involved when the escort arrived, then how do we now, in light of that, how would we consider things like the con trip?
Well, then I would say then it doesn't count. But I think what I was getting at, and I don't think I was very clear, so if I may, I'd like to explain it a little better.
That this is that the thing that happened at the hotel is in fact what he intended to happen, as opposed to his argument that no, I wanted people to travel so that I could have an attractive scene, but if there was actual, sexual activity that followed, that was just something that happened. But by showing a video of people engaged in such activity in close proximity to the event that actually transpired with the activity, it showed that his purpose in making this whole arrangement was to have the activity occur, and that manifested his intent.
But that's not sufficient to establish a Mann Act violation. The purpose of the travel has to be...
Well, it's not sufficient, but it certainly contributes to it, because you have to have intent, right? So I could arrange for the intent of anyone to cross state lines, and then various activities could happen. But it's not a Mann Act violation unless I transport them with the intent that those events transpire, right?
Right, that's my point.
So that's what I'm saying, is why does this not go to prove his intent, which is an element of a Mann Act violation, that the reason he had the people, the escorts, travel across state lines was so the activity would happen?
I think that gets back to the point I was making earlier, that under our view of the acquitted conduct guideline, that is just too far afield, and it's basically like a relevance test. You're
Well,
saying
how do you prove his intent then?
that.
So what evidence, are you saying that some evidence of his intent does count as offense conduct and some does not?
Well, first of all, if you actually look at her testimony, I don't think she testifies to what Your Honor just articulated, and in fact, the testimony establishes that they got to New York and then they had dinner, and he suggested a free off after that.
Well, right, this is a question for the jury to infer about whether the temporal proximity between him showing a video to her on the plane and then immediately getting back to New York and suggesting it and having it play out is why he wanted the escort to be traveling.
But there's no basis from which to conclude that the jury even found that this particular incident constituted a Mann Act.
Was this incident cited in connection with the Mann Act charge? Did the government ever point to this and say this is a Mann Act violation?
No. The Mann Act, the government's discussion of the Mann Act in its closing argument was focused on this charge.
So let me, we have to write an opinion here, and let's just step out of the weeds, and we have to enunciate a principle, right? And the guidelines, the discussion of the guidelines talks about line drawing exercises that courts have to engage in to determine where there's overlap, where acquitted and convicted conduct overlap. Can you articulate a principle that for us to apply, if you were writing the opinion, what principle would you enunciate that is, readily administrable by courts to engage in this line drawing exercise? Can you give me a bright line test of some sort?
Yeah, let me try. If I may, I'll try to illustrate it with some hypotheticals. So I think the test should be, and what the commission intended the test to be, that courts cannot use acquitted conduct for guidelines purposes unless the defendant was also convicted of that conduct. And in order to determine what that means, you would look at whether the same element that has to be proven in connection with acquitted conduct has to be proven in connection with element or elements convicted conduct. So, for example, let's suppose you have a case in which a defendant is charged with drug conspiracy to distribute narcotics, as well as several substantive counts of distribution. And the defendant is convicted of the conspiracy and with respect to the substantive counts is acquitted of some and convicted on others. When determining the drug amount, the court could not count the ones the defendant was, the weight from the ones the defendant was acquitted of for the substantive counts, but could count the ones the defendant was convicted of, as well as any other drug deals that were either proven at trial or are proven at sentencing if they're not charged in separate substantive counts. That's one example. Another one would be you could have a fraud case in which the defendant is charged in securities fraud as well as wire fraud.
Hello,
and
everybody.
it's the same exact scheme to defraud, the same false representations in both counts, but the defendant is acquitted of one and convicted on the other. The way to make sense of that is to say it's clear the defendant has been convicted of the scheme to defraud, and so you could count the entire loss amount, even though he was, let's say, acquitted of wire fraud. Either because maybe the jury didn't find the wire in furtherance or something like that, but it's clear that they did find the scheme to defraud proven because the same conduct underlies the element in both charges.
To what extent does your theory rely upon the, what the government argues in terms of the evidence? In other words, the case that's presented to the jury in terms of the elements. Is that dependent upon that, or does that matter? Is that irrelevant?
I think it depends on the case. I think you have to look at the indictment and what's the charge and what's the government's theory of the case. So,
the theory of the case as presented to the jury. Right? It's not their theory of the case in the abstract, what may be in the indictment, but it's what is actually, they have a case to prove, right? So wouldn't it be the evidence and the arguments that the government makes to the jury?
It's definitely very important, and I think that's why, that's why we think that the test that's used for collateral estoppel is.
And was any of the evidence and the arguments the government made here in connection with the RICO and the sex trafficking offenses, was any of that evidence presented to the jury for purposes of persuading them to convict on the Mann Act?
Yes. I'm sorry, were you asking just about the RICO or the?
No, both.
Yes.
So to what extent did the government's case at trial on RICO and sex trafficking overlap with the government's evidence and arguments on the Mann Act?
So, as the government said, itself said it was totally separate, but with, from the sex trafficking counts, the overlap, well, let me just back up. I'm not
Should the
sure.
district judge hold the government to that for sentencing purposes? I mean, should the district court say, well, you put in all this evidence that the jury rejected, right? And now you want me to look at this evidence to support a conviction under this other, to support a penalty under this other offense that you were convicted on, but you didn't present any of that evidence to the jury.
I think you have to just start with what are the elements that the government had to prove.
Yes.
And
They went
so
prostitution.
if they didn't have to prove, for the Mann Act, if they didn't have to prove coercion, they didn't have to prove a co-conspirator, then we know that there is no convicted conduct that includes coercion or co-conspirators. And that's really the starting point. And I think the evidence and the arguments just reaffirms in this case that that the evidence that the judge was relying on is totally separate and in fact was acquitted conduct because
Well, he's mixing and matching is what he's doing, right? I mean, the district court here reached into the evidence that was used to support the government's RICO and sex trafficking case to for purposes of establishing the penalty under the Mann Act.
Correct, and he found coercion when when the jury had not found coercion, including as to those two specific instances, because the government made those arguments and expressly told the jury, which correctly under the jury instructions, that if they found coercion, each of those instances would have been sufficient to convict on the substantive sex trafficking.
Were there limiting instructions given or requested during trial that certain evidence would only be admissible with respect to certain of the charged offenses?
No, and that wouldn't really have worked here because there was a RICO charge, and as I'm sure Your Honor knows, under RICO, basically everything.
Well, everything would have come in
under
as
the
to
sun
RICO, but the idea that it's admissible as to RICO, but not admissible, say, as to the Mann Act.
But
So,
that
I guess
would
what
not-
I'm going to
That
is,
would not have been legally permissible in this case because the Mann Act was also predicate acts to the RICO. I mean, that just wouldn't have been a valid instruction.
well, I guess where I'm going with this is, does that mean that all the evidence that was admitted would have been legally admissible to prove any of the particular offenses? So, going towards Judge Baker's hypothetical, is there a scenario here where the judge was pulling evidence that was not, I don't know what you would say, admitted for purposes of proving the Mann Act, and then it's impermissible, say, for the judge to look at it with respect to the Mann Act when he's at the sentencing period? And I guess what I'm asking is that in fact the case here, or was all of the evidence admitted for unlimited purposes such that there is no, as long as it would be relevant and probative to prove up another count, then it would have been permissible for the judge to consider it with respect to that count?
Well, I think the reason it's not permissible for him to consider it is because it's acquitted conduct. And the judge.
Well, right, but I guess
judge made
let's
clear
give you
that
that.
he
Let's accept
accepted-
that. Let's accept that premise for the purposes of my question, that yes, it would underlie some of the acquitted counts. I think then the question becomes, is it overlapping, right? So would it be permissible nonetheless to consider it with respect to the convicted counts?
No.
And right, and I understand your answer is no, and I'm trying to get at why. So is it because it wouldn't have been admissible to prove the Mann Act count? In other words, does your argument depend on that at all? Or I think what I hear you arguing is if there is an element of the acquitted charges that does not match an element of the convicted charges, what is embodied in the element of the acquitted conduct, which here is coercion, fraud, is now completely off the table for sentencing. Is that your argument?
So that is our principal argument.
Okay.
There's a secondary argument, and I hesitate to even raise it, but it's, we've made it, that even if you actually adopt the relevance test that the district court imposed, that these things wouldn't have been relevant, but I don't think the court should
the relevancy
go
test,
there.
I find your argument confusing on that because I think
Well, it's
the
not a
district court
ruling
is-
made,
holding
I
is
think,
That's just a
frankly, I think
fallback.
your brief mischaracterizes, sort of caricatures the district court's use of the word relevancy. I don't think he's saying relevant in the sense of relevant conduct under the guidelines. I think he's taking relate to in context of having probative value with respect to one of the elements of the convicted offense, which is another way of saying it would have been admissible evidence to prove an element of the charged offense.
I think that's right. And our point in the briefing below on that, especially, and I think we make this point in the opening brief as well, is that that test is far too broad.
But it's not
basically a
coextensive with
Rule
relevant
401.
conduct. Because I think in your brief, you say that blows up the acquitted guideline because it would basically, it's just a circular definition with relevant conduct. And I think that's not what the
Well,
judge was saying. It would be a smaller subsection of things, much smaller subsection of things than anything involving relevant conduct.
I don't agree, Your Honor, and I think that it's a distinction without a difference because the concept of relevance, as the district court was using it, as Your Honor seems to be using it, is the same as Rule 401, which is incredibly broad, and as this court has, repeatedly held, it's a very low bar, and it basically sweeps in, many things. And it's-
Well, no, take this. Defendant is convicted of one bank robbery. At sentencing, the judge considers 10 other bank robberies that were committed on completely different days using, and let's posit, completely different modus operandi. But it's relevant conduct. And so the judge considers all 11 bank robberies when calculating the guidelines. I don't think that one would then say that had there been a trial on bank robbery 1, all of the other 10 bank robberies would have come in as relevant evidence because under my hypothetical, where there was no common MO, they would not be admissible under 404B. So I don't think if you draw a Venn diagram, you're going to find perfectly coinciding circles for relevant conduct under 1B1.3 and relevance under the rules of evidence to prove up an offense.
Well, even if that's the case, on what we're dealing with here, this evidence of coercion would not have come in to prove the Mann Act. Clearly, it would have violated 404, 403. There are numerous reasons that I think it's pretty indisputable that if all Mr. Combs had been charged on and all he'd been tried on was Mann Act, that we wouldn't have,
But what about the idea that if he had, let's say he was only charged with the Mann Act and his defense was along the lines of one of the things the defense raised at trial, which is he never intended for the specified activity to happen after these folks crossed state lines, that it just kind of happened. And one of the ways the government tried to disprove that or tried to prove his intent was saying, no, he used to talk about this all the time, what he wanted to happen. In fact, there was one time on a plane that within 24 hours before the event happened, he actually showed a woman videos of prior episodes where the activity had happened. And sure enough, within 24 hours, that's what he arranges to happen. Again, that's proof that this is exactly what he intended to happen. It is not mere coincidence. Why would that not be admissible?
That's not what the defense to the Mann Act was. Most of the case was focused on the coercion in the RICO, and to the extent...
I thought that was part of the defense, no?
No, it wasn't, Your Honor. The only arguments that were made specifically about the Mann Act by the defense was the argument that, based on the testimony of the and the evidence in the case, was that the escorts were paid for their time.
Well, right, that's the same argument. They were paid for their time, and everything that happened afterwards was just not something that he was arranging. He was not transporting them for the purpose of what happened afterwards. It was just their time.
I guess I'm getting a little lost. I apologize. But I think the point here is that the principal point here is getting back to Your Honor's earlier questions and my dialogue with Judge Baker, is that you have to look at the elements. That's our position. You have to look at the elements. This idea that you have a relevance test is
Right.
not
But
consistent.
your argument-
with the guideline. And I just want to highlight, I'm sorry.
Well, no,
Go
there's a
ahead.
question.
Sorry.
I'm sorry, well, finish your point, and then I have a question.
I just wanted to highlight, and we've mentioned this in the briefs, but if you look at the history of the guideline, the Department of Justice wanted the commission to use the phrase relates to in the guideline, and the commission rejected that because they thought that was far too broad, and they went instead with the language that's in the guidelines.
So the problem that I have with your test of an elements test is that sometimes the problem is we have different elements, right, for the RICO, for the sex trafficking versus the Mann Act. But there's evidence, conduct that can underlie the government's case, right, in all these sets of charges. And the mere fact that you're, acquitted doesn't, by the, very plain terms of the guidelines, right, it doesn't take it off the table insofar as that conduct is also convicted conduct. And so what we're trying to discern here is where's the line, right, for purposes of sentencing. And so you just can't rely upon a test of because it cannot be that just because in all conduct that is underlying the element of acquittal is then taken off the table, right? It can't, by itself.
Well, I don't agree with that, because I think it's going to depend on the case, right? And there are going to be cases that are maybe closer than this one.
Right.
So you're going to have cases, for example, where there are maybe inconsistent verdicts, things like that. That's not the case here. This was very clear. I sat through this trial for 8 weeks. The government's focus from beginning to end was on the sex trafficking and the RICO. The whole, where the debate was there coercion or was this sex voluntary?
Right,
That was the gist
The
of
Mann
what
Act was an
being
afterthought.
disputed.
It was an afterthought. The Mann Act was just an afterthought in the government's prosecution. I mean, it was there, but it was effectively a sideshow. But that's the question, right? Can the government then look to all this, or can the district court look to evidence presumably rejected by the jury and acquitting on these other things for purposes of finding the penalty in the sideshow? And why shouldn't we just hold the government to what it argued?
We should, absolutely. And I think the whole point of this guideline was to deal with the fact that many people in America, not just Supreme Court justices, not just other judges, but, have really questioned whether it is both constitutional and right and consistent with respecting jury verdicts to allow acquitted conduct to be used to drive a sentence in this way. And I want to highlight that, and we mentioned this in our brief, but I'm not sure we gave it the prominence it should. This sentence was the highest sentence ever imposed for a Mann Act defendant sentenced under the same base offense level and criminal history category.
Well, let me ask you about that.
You should have opened with this.
Would this offense let's take the violence off the table, right? The allegations of violence that the jury rejected in the acquitted counts. What about would this verdict, would this sentence be
Chuck.
substantively reasonable, in your view, given that we also have factual findings of psychological abuse, emotional abuse, and applying these two women with drugs? One of them became an opioid addict as a result of it. Would presumably that's still on the table if we take away the violence?
I think that it would be substantively unreasonable under the correctly calculated guideline range, because it would be multiples, it would require a variance upward based on the acquitted conduct.
But that's not, but the guideline range is just, it's not a per se rule. It's a guideline, and it's a starting point, But then you look at the facts of the case, and we have two statutes that tell us you look at all these factors, and we have one statute that says there's no limitation. And am I correct in understanding that we have this factual finding that we have two women who applied with drugs to participate in this, and one of them became an opioid addict? And so doesn't that support the reasonableness of this, putting aside the violence?
Well, a couple of points. First of all, you're correct that that's what the district court found. The evidence in the trial is much more complicated than that.
But you don't challenge on appeal those factual findings. You're not challenging that factual finding. You're making legal arguments.
But this court has to review the sentence based on the guidelines calculation taken as a starting point, and this is actually where I was going. I don't even think I got to this.
You didn't.
The Supreme Court in Martinez-Molina and this court in Seabrook and many other cases have held that a guidelines miscalculation is a significant procedural error that requires a remand and resentencing in most cases, even under plain error review. And so, for instance, this court has held that if you accept the guidelines argument, even in part, a significant upward variance would have been required, and a remand is required because the judge would have had to explain that variance. And indeed, this court has held that even where the sentence is within the range of the correct guideline range, a remand is necessary.
But sometimes, oh, go ahead.
Sorry, what do
No.
we do with the fact that the district judge here, after each guidelines finding, made the statement that he would have imposed the same sentence with or without this increase? It seems to me that if we accept the judge's representation that that guidelines decision, it was not what drove his ultimate sentence, that then moves us into the question of whether he could have used the acquitted conduct for the 3553A calculation. But how do we get over that sort of potential harmless error hump that he did make that statement after each increase was imposed?
So this court has repeatedly held that a major variant, that the district court cannot insulate itself from appellate review by saying that he would give the same sentence. The Seabrook is one example. We've cited others in our brief, and the Supreme Court in the Molina-Martinez case, and this court and other cases have pointed out, for example, that this isn't like a new trial and a resentencing,
Yeah, but sometimes we have affirmed. I mean, I understand. You can point to some cases where we say, you know what, we're not sure the guideline error really was harmless. We don't know. The judge said it wasn't, but we don't have a high level of confidence. The judge was very emphatic here.
well,
And careful. So it doesn't sound very boilerplate. It doesn't
it's
sound like
also-
anything the district judge did here was
it's also clear
boilerplate.
that the acquitted conduct drove the sentencing.
And then we would get into the Sixth Amendment issue, right?
No. I'm talking about the guidelines calculation as a starting point. And the other thing that is really important here is that the district court's guidelines calculation exactly mirrored the PSR, and it seemed clear that the district court was really planning to follow the PSR, and indeed, when he imposed the sentence, he initially said he was following the recommendation.
Wait a minute. Are you implying that the district court wasn't thinking for himself and that he was?
No, not at all.
Then
My
what does
point-
this argument about tracking the PSR have to do with anything?
It has to do with the fact that the guidelines range was very important in the ultimate sentence.
And you're saying that the district court must have placed the same weight on the guidelines that the PSR did?
No, that's not, I'm
Then
just
what
saying-
is the implication? I'm trying to understand what your implication is. Because it sounds like you're going to a place where the district court was not thinking for itself or was somehow implicitly adopting parts of the PSR that it didn't or something.
No, Your Honor, that's not what I'm saying.
Then what are you saying?
My point is simply that this court has repeatedly held that significant procedural errors require remand. I mean, two of the cases.
That I
Bennett
understand, but
and-
no, I want to go back. What were you talking about with the PSR? Because
What
I
I'm
don't
saying-
understand that point.
Okay, what I'm saying is that you don't know what the district judge would have done if he had understood the guideline range to be either 21 to 27, which it would be if you accept all of our guidelines argument, or 30 to 37 if you get rid of the grouping, just for example.
Even though he told us what he would do. I
Because-
understand the argument. I would understand. I don't think you made it quite this way, but maybe this is what you meant to say, that if we agree with you that all of his guideline enhancements were wrong, he never said, and even if all of my guideline calculations are wrong, I would do the same thing, as opposed to any individual thing. So if we found one guideline error, though, he said to us he would have done the same thing, and you're saying that we don't take that at face value?
That's correct, Your Honor, under the precedents. And
Well, some of them we do. I mean, there are some cases where we have reversed and remanded, and there are others where we said, well, the judge told us he would do the same. So it's harmless.
We don't have a case where there would be a significant upward variance like this. We don't have another case the government could possibly cite where the sentence was the highest sentence for any person in this criminal history category and base offense level, even including others who had a coercion enhancement. There's no case remotely like that that the government could point to. And indeed, some of these cases involve things like in the Bennett case, I forget the name of the other one. In a couple of the cases, the judge says the guideline range is X, which is a little bit above the statutory maximum, and then sentences well below the statutory maximum. And this court says it has to go back because the judge thought the guideline range was higher than the maximum. So, in that case, clearly there's been a significant departure from what it could have been, and the judge gives reasons, but the court sends it back. And that's what the court should do here. That's what's required by those cases.
Okay.
I understand your argument. I mean, I fully understand your arguments about the acquitted conduct for purpose of the coercion and leadership enhancements, right? Those were four points apiece. But when it comes to the victim, the characterization by the district court of Ventura and Jane and the escorts as victims, it's not really, as you framed it, it's not really an acquitted conduct argument. You're just arguing with or disputing the district court's characterization of these people as victims. So that doesn't really fall into the acquitted conduct bucket for purposes of deciding this case.
I mean, I think there's two issues that we're raising there.
I know the law professors agree with us on that because they don't join you on that. The law professors who filed you, by the way, a very helpful brief. I'd like to thank them for that. But that very helpful brief they stopped when they got past coercion and leadership.
That's fair, Your Honor. I think our principal argument on that, we are arguing that the acquittals show that the jury didn't believe the two women were victims, but our principal argument there is that the term victim should be interpreted according to its plain meaning, which is someone harmed or injured by the offense, and that the application note is inconsistent with that plain meaning. So even under Stinson, the grouping calculation was incorrect, and we're also preserving for further review a challenge to whether Stinson is good law.
Right, but so for acquitted conduct purposes and looking at harmless error and how this might have played out if there was a mistake under the guidelines, we're only looking at we're talking about
It's almost double.
Right. Well, it takes us from, if we did 8, it would take us from, that would go from, we went from 50, would take us to 20. It's only, we're talking about 8 points, right? We're going from level 14 to 20.
The range would be 30 to 37 under that scenario, as opposed to 70 to 87, which was the starting point.
Can I ask you about the definition that the commission has given us of acquitted conduct? One of the things you pointed to contest the government's view is that there was a government proposal that acquitted conduct be defined using the word relating to or something like that. Related to. And the government has also pointed to a proposal that was before the Sentencing Commission that would use the word elements. And neither one of those was adopted. And instead they took this other definition that, as far as I can tell, they decided they didn't need to define further, and said something along the lines of, don't worry, it won't come up that often, and it's going to be really easy. District judges are going to be able to figure this out. Why should we worry about line drawing? And as I recall, there was a letter from the Judicial Conference Committee on Criminal Law warning them that this was a very
issue.
ambiguous guideline,
Yep.
and that they very much should provide more clarity. And they didn't. They didn't take an elements test, which I think would have been very clear, and they didn't take the government's relating to, and they gave us one that says, don't worry, district judges are going to figure this out. And I don't know, maybe the district could figure it out. I'm having trouble as an appellate judge figuring it out. What are we to make of it if we decide that it is ambiguous? Does the rule of lenity kick in to guidelines issues? Are there other
Lower
interpretive
guideline
principles?
There are two interpretive
Procedurally.
principles. So one would be the rule of lenity, and the other would be the related, but maybe more important, constitutional avoidance principle. And even to the extent, I understand the panel's position regarding, or Your Honor's position regarding the binding nature of those precedents we talked about earlier. But putting that aside, I think it's clear that at a minimum, there are serious constitutional concerns with using acquitted conduct. And so I think, if the court finds that the guideline is ambiguous, it should be interpreted, the exception should be interpreted narrowly in favor of the defendant.
And this is, I swear, my last question. I don't know about my colleagues. Are you aware of any other appellate courts that either have decided this issue or are facing it right now? Is this bubbling through the circuits in other ways where we are soon perhaps to benefit from the views of our sister circuits?
I am not aware of any other appellate decisions interpreting the guideline. There are some decisions, relating to the Watts issue, but.
Sure, but you're not aware of anything currently bubbling?
My colleague advises me that there's a case pending in the First Circuit on this.
Do you have it? Well, that's fine. Well, if it comes out, that's fine. If it comes out, we'll find it, but that's helpful.
Okay.
Unless there are any further questions, we have kept you up considerably past the 10 minutes, so, but don't go away, because we're going to see you again in rebuttal.
I'm sure I'll have more to say.
I hope you have a bottle of water there.
Oh.
We will now hear from the government.
Good morning. It might be afternoon at this point, but may it please the court, my name is Christy Slavic, and I represent the United States on this appeal as I did in the district court proceedings below. Judge Subramanian correctly applied the new acquitted conduct guideline in this case, and moreover, in determining the appropriate sentence under Section 3553A, Judge Subramanian properly considered the aggravated manner in which the defendant carried out his Mann Act offenses, which is, of course, consistent.
You say aggravated manner. Let's talk about that. Why shouldn't we hold you to the way you prosecuted the case? You went to the jury and you said, this man did all these terrible things for purposes of the RICO conspiracy, for purposes of sex trafficking, and they acquitted him. And then on the Mann Act, it was just a sideshow, and you put in, I don't think there was any evidence or any live witness testimony. Just look at this, you said, look at these charts. And now you want us to rely on all this acquitted conduct that was presented to the jury that was presumably rejected for purposes of, or to allow a district court for purposes of the guidelines calculation. So why shouldn't we hold you to what you argue to the jury?
Your Honor, I have several responses, but
Please.
First is that much of the conduct that the district court focused on in imposing the sentence was not acquitted conduct at all. In fact, it was admitted conduct. The extreme physical violence that took place in the context of these freak-offs
That's
and
not,
hotel...
I get all that. I understand that. But that's not my question to you. My question to you is, why shouldn't we hold you? It's not what the government, what the district court relied upon. I'm asking why we shouldn't hold you in terms, or require a district court to hold the government to what it presented to the jury for purposes of, for deciding the scope of acquitted conduct, to look at what you actually presented to the jury for purposes of those charges, and then asking, did it overlap with the acquitted charges? And I don't think there's any overlap here.
Sure. So just backing up a moment to talk about how the case was presented. Counts 2 and 4 were the sex trafficking counts, and those, of course, were acquitted counts. Counts 3 and 5 were the Mann Act counts. All counts were charged as courses of conduct as opposed to specific instances. And for counts 2 and 4 that related to Cassie, that course of conduct related to the freak-offs that took place between 2009 and 2018, I believe. With respect to counts 4 and 5 that related to the hotel nights with Jane, that course of conduct was from 2021 through 2024. So the evidence of the hotel nights and the freak-offs related both to the sex trafficking and to the Mann Act charges. And that's how it was presented to the jury. It was never presented as this evidence relates to sex trafficking and this evidence relates to the Mann Act. There was never a dividing line.
But when you get to summation, there is, right? So you say, let's start with count 3. The defendant is charged in count 3 with interstate transportation for the purpose of prostitution related to freak-offs involving Cassie. That's how you describe count 3. I think that's right. And then you go on to talk about all of the evidence about escorts traveling. And it doesn't talk in your discussion of count 3, and similarly, it's a very, very mirrored for count 5 when you talk about Jane Doe. Doesn't talk about Ms. Ventura or Ms. Doe being coerced, or Ms. Ventura or Ms. Doe being transported. It says count 3 is about escorts traveling for the purposes of contact with Cassie, and count 5 is about escorts traveling for the purpose of contact with Jane. As Judge Baker is saying, where else can we divine the government's theory of those two counts other than summation, and why shouldn't we hold you to it?
So just to be clear, the government's theory was that the travel involved both Cassie and Jane and escorts. But I think
that what you said in your closing.
I don't have the exact words of the closing, but that was. I think your other question is, why shouldn't the government be held to what it argues?
Let me just stop you for a second, because the last thing you say on count 3 is, quote, all of the examples that I just went over showed the defendant caused commercial sex workers to travel across state lines for freak-offs. The defendant is guilty of count 3 based on any single one of these instances. Then you say, let's move to count 5. So that's how you started and ended count 3.
So the point was, the government, in closing, went over several examples. It was not a comprehensive list of all the instances of travel because...
No, but the theory was that he caused commercial sex workers to travel. That was the theory on which you asked the jury to convict Mr. Combs on count 3.
Sure.
Not that he caused Ms. Ventura to travel or that he coerced Ms. Ventura into something. The theory was he caused commercial sex workers to travel. Other than the constitutional challenges, there's no sufficiency of the evidence challenge to that for good reason. It looks pretty much like he did. But that's the government's theory, right?
That was the government's argument at closing. I think, kind of backing up, the import of this line of questioning is, shouldn't we hold the government to what it argued in closing? And I don't think that that's right. I think the theory is, if the government made this argument, doesn't that mean that the jury accepted that argument and didn't consider any other possibilities? And I don't think that that's a fair inference.
But what we're trying to do here is to figure out where, draw this line. So the jury acquitted on certain things and then convicted on other things. So what does a jury have to rely upon? Don't you think they're listening very intently to the closing argument? Isn't that going to be very, very important in their consideration?
Of course, Your Honor, of course. But the jury in this case, was properly instructed on each element of the Mann Act and had to find each element of the Mann Act met beyond a reasonable doubt. And I think it's, as a logical matter, I think it's an impossible task to discern the minimum quantum of evidence that would be sufficient to sustain the government's burden. And I think that sort of inquiry also goes against this court's precedent, specifically the Martinez case that says a court only knows what the jury's verdicts were, not what the jury found.
Well, right. No, and that, I don't think anybody's questioning that. But the problem for the government is that there's a new guideline that says, figure it out, that basically says there is such a thing as acquitted conduct. And as Judge Subramanian pointed out, I think quite accurately in sort of speaking with the greatest amount of precision possible, there is no such thing as acquitted conduct. Juries don't acquit people of conduct, they acquit them of charges. They find that certain elements were not proven beyond a reasonable doubt. They don't find that someone's innocent. But now the guidelines have been amended, so there is a thing called acquitted conduct. We've got to figure it out. So the question is, how do we measure that? So we're not looking at general principles like Martinez saying, did the jury find something? The only place that you're going to find, I think, in our case where we say an acquittal necessarily implies something is in our collateral estoppel branch of double jeopardy jurisprudence. And I think, I guess one question I would have for you is, why would that not defeat the government's argument, at least with respect to coercion in this case, if, for example, the jury had hung on the sex trafficking count, right? If the jury had hung on, well, no, no, my hypothetical is spinning out of control. I guess what I'm wondering is if there was some hypothetical additional count that the jury had hung on here that required a finding of coercion with respect to one of the two victims, why you would not be collaterally estopped under the double jeopardy clause from retrying the defendant on that count. Let's say there was a conspiracy to commit sex trafficking.
Well, let me just push
Why
back
would that
on,
not be
Let me just push
precluded?
back on this hypothetical that a foundational issue that I have is that the defendant was not acquitted of coercion. He was acquitted of sex trafficking by force, fraud, and coercion. The jury was never asked, was there coercion?
Right, but we have,
Sorry.
well, under that theory, there is no such thing as acquitted conduct. So you're kind of fighting the very principle of the guideline. You're saying that because there were three alternate elements, I think, fraud, force, or coercion, that because there are three alternate elements, there is no acquitted conduct. But you have to accept the premise because the guidelines have been amended. There is such a thing as acquitted conduct. So why don't you actually, let me frame it this way. Under your view, with respect to count two, what is the acquitted conduct?
So the commission thought very long and hard about this issue, clearly, and they declined to set any bright line rules defining.
Yeah, but now here we are.
Exactly.
So what's the government's view of what the acquitted conduct is underlying count two?
So I think Judge Subramanian's test, which is...
No, that's, I think Judge Subramanian's test is what's overlapping conduct.
As a first step to Judge Subramanian's test, he described acquitted conduct as conduct that underlies the...
Yeah, so you tell me what
that-
conduct underlies count two.
What specific conduct? Yeah. Well, I think a good example of conduct that could be considered acquitted conduct that the judge did not consider in applying the exception was the intercontinental video. That, of course, was evidence presented at trial that showed the defendant assaulting Cassandra Ventura during the course of...
So that's acquitted conduct in your view?
I think that that's a fair characterization.
So that's a use of force, but the other conduct that illustrates use of coercion is not acquitted conduct.
The reason that that's acquitted conduct, in my view, is because that does not tend to prove the elements of the Mann Act.
No.
That's the second question.
No. There's two things here. You can have acquitted conduct and you can have offense conduct under the guidelines, and they can overlap. And that's why the guidelines say where they overlap, you can consider them. So the government sort of doesn't lose by saying something's acquitted conduct here, because then the district judge, if it's overlapping, can still consider it.
Right.
So let me ask it this way. There is evidence on the flight back from Cannes that Mr. Combs sits next to one of the victims and shows these videos of the events that have happened in the past, and the government's argument to the jury is that's coercive, right? That this was an implicit threat, right? His discussion of releasing these videos was implicitly, if you do not continue to engage in this conduct, I will release this publicly, and that will destroy your reputation, right?
That's right.
So it seems to me that that's clearly acquitted conduct. I thought the government's argument is that it is also offense conduct. And therefore, because it's overlapping, the judge was allowed to consider it. So I want to ask you about just the first part of my question.
Okay.
In your view, did what Mr. Combs did on the plane back from Cannes also constitute acquitted conduct?
So I think the answer is maybe. I think it depends on the definition of acquitted conduct.
Okay, under the government's definition, is it acquitted conduct?
I think the judge properly.
No, under the government's view. Forget it. Let's pretend it's before sentencing happened. Under the government's view, is that acquitted conduct?
I don't think that because the defendant was not acquitted of coercion, I don't think it's
was he
necessarily.
not?
Because
Unless
he-
you're saying he wasn't acquitted of anything. Because if there was fraud, if there was force, there was fraud or coercion, he's guilty, right?
What I'm saying is, no, I don't think that that's right. It's not just if there was force, fraud, or coercion, he's guilty. He had to know or recklessly
Right, there are
disregard.
multiple of elements. But I think what your argument would lead to is that there's no such thing as acquitted conduct, because there's always multiple elements. One can't, from a jury's acquittal, ever know which of the elements they found unsatisfied. Ipso facto, there's never a category, there's never a bucket that's filled with something called acquitted conduct. Tell me why I'm wrong about that. In what world is there a bucket that's full of acquitted conduct in your position?
Your Honor, I think this case is I think presents a lot of gray lines, and I think that the cases that come up in some of the dissents that the panel has already mentioned related to drug cases, for instance, where there's a conviction on a conspiracy count and an acquittal on a distribution count, or vice versa. And there's a special interrogatory where the jury finds specifically some amount of drugs. Like, I think that is very easily described as acquitted conduct.
Absent a special interrogatory, when does your test yield anything that constitutes acquitted conduct?
Your Honor, I think that in those sort of more straightforward cases where facts were presented directly to the jury and rejected by the jury, I think.
When does that ever happen except with a special interrogatory?
I think that can happen in, for instance, a 2-count drug distribution case. In one count, there's a conviction. In one count, there's an acquittal. I think the acquitted weight of the drugs would be.
Well, but each of those counts, let's assume it's a distribution count. Each of those counts has multiple elements, right? Knowing what the drug was, distributing it purposely, right? I purposely handed it to you, that's how I knowingly distributed it. But also knowing that it was heroin, right? Because the defense might have been, oh, I thought it was fake drugs. I thought I was cheating, right? Each of those has multiple elements. So you're always going to be in a position, if you're the government, taking the position I think you're taking, of saying, well, I don't know whether the jury found that he didn't know it was heroin, or I didn't know that he thought that he was purposely distributing it, or whatever it might be. So I don't understand your argument.
I think going back to the guideline itself, which does create a thing called acquitted conduct and convicted conduct, the commission deliberately did not define either term, leaving us in this position.
But it clearly must have some content.
Exactly, I think that's right.
And it can't be what we have always said under the Sixth Amendment is true, that there is no finding implicit in a verdict of acquittal. So that's off the table as to what the commission was trying to say.
That's right, Your Honor. And what the commission did say is that the court is in the best position to determine what is acquitted conduct and what is convicted conduct.
According to some rule of decision, not in terms of arbitrarily deciding A in one case and B in another. So we are tasked, as the district court was, with coming up with an articulable rule.
Sure.
So here we are.
And can I ask you, please, to articulate what's the principle? We have to write an opinion. It's the same question I posed to your friend. We have to write this opinion. What is the principle that distinguishes acquitted from convicted conduct?
So acquitted conduct, one thing that I think is supported by the commentary is that conduct that underlies an acquitted charge can be considered acquitted conduct. That's like the first step. The second step, of course, is whether that conduct can nevertheless be considered as relevant conduct. But that first step, what is acquitted conduct? What Judge Subramanian did is said, acquitted conduct is conduct that underlies an acquitted count, right? And under that definition, in this case, there was a lot of overlapping conduct. And so he had to determine what
So how do we know
overlapping-
whether there's overlapping conduct? Where do we look to determine that?
I think that's where the judge's discretion, the judge who's overseeing the trial.
But this is, we're trying to find out what the purpose of the guideline is to make sure that the jury's acquittal isn't negated. So we're trying to understand, this is difficult, right? We're trying to understand what the jury did. And we have a conviction and we have an acquittal, right? So we're trying to understand what the jury did.
So I think that the appropriate test here is the test that Judge Subramanian articulated, which is to assess whether the conduct can still be considered as relevant conduct for the purposes of the guidelines. He looked to whether that conduct tended to establish an element of the convicted count. And in this case, those two narrow instances.
Well, let me ask you that. Why does the coercion tend to prove, say, with the conflict? Why does the coercive nature, or the coercion, strictly speaking, tend to establish the Mann Act, as opposed to, let's take coercion out of the equation, the fact, you can still look at the underlying raw facts, Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the videos and all that, that evidence could still be considered, say, fairly, to ascertain what Mr. Combs' intent would be for the events that would follow, and yet it could not, say, under the defense's view, be considered for purposes of establishing coercion, because coercion was an element of one of the acquitted offenses.
So I think, to answer your first question, which is how does the travel in Cannes and the situation on the airplane, how does that establish the Mann Act? I think it's for the reasons that Judge, you articulated in your colloquy with my
And
colleague.
I'm saying, let's grant you that. Let's hypothesize that the events on the airplane are admissible and were properly considered by the judge to figure out, did Mr. Combs really intend what was all going to happen was going to happen? Let's just posit that. But isn't there a world in which the guidelines say, yeah, you know what, that's fine. Consider it for purposes of the Mann Act elements. But you can't draw the further conclusion that that was coercive in nature.
Well, the guidelines.
Because that's what the jury said did not happen, or did not find happened, and therefore it's acquitted conduct.
So I think because this acquitted conduct tends to prove an element of the
But how
Mann
does the
Act.
coercive nature of it, the inference that it was coercive, because I think that's really a distinct fact, right?
That inference is coercion is defined in the guideline. The fraud and coercion guideline, or excuse me, enhancement is set out in the guideline. And the definition under that, coercion under that
Well,
enhancement.
let's assume it is coercive conduct. I think what Judge Nardini's asking, and I have the same question, is how does the fact of its coerciveness tend to establish some, in whole or in part, an element of the Mann Act offense?
I think it relates to the temporal proximity between the coercion, the threats, I'll call it, the threats, the transport, and the demand for a freak off.
So let's say the conversation instead was, instead of it being coercive on the plane, was when we get back, my plan is to fly some escorts in and you're going to have sex with them, and I'm going to pay them for that.
Sure. I think that would establish the intent.
Exactly. So why is the additional aspect of that conversation, that encounter on the plane that's described, that the coercive aspect of that, why is that add anything to establish in whole or in part the Mann Act offense?
Because I think it's what he's asking for. It's the threats are not followed by a request to go to dinner, a request to, ask Cassie to do the dishes. Those threats are followed by a demand for a freak off. So the coercive nature of the threats are directly relevant to the intent to have the freak off, which then later happens.
Well, okay. Except you've agreed that it didn't need to be coercive in order to support that aspect. The
No,
intent
not
aspect of the
necessarily.
Mann
It
Act.
just so happened in these two specific instances, the threats did amount to coercion under the enhancement. And I think that was, I think Judge Subramanian.
Can I ask you a hypothetical? And I don't know, it doesn't map onto this case, but I'm trying to make sense of the acquitted conduct guideline. We have a defendant who's charged with murder. He points a gun at the victim's head. He pulls the trigger at point blank range, kills the victim. He's charged with first and second degree murder. The jury acquits of first degree, which would have required a finding of premeditation, but it convicts of second degree murder. Let's say it was, I don't know, some sort of heat of passion or something he just did on the moment. Comes to sentencing. Is the premeditation, which is purely mens rea, in your view, acquitted conduct or not? And if so, is the judge, in my hypothetical, allowed to make a finding of premeditation by a preponderance and sentence the defendant accordingly under the guidelines?
So the premeditation, I think.
Because what I'm trying to do is draw a distinction between the actions, the physical actions, and I'm going to analogize that to Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the video, saying the words he said. Those are sort of raw facts. Mm-hmm. Clearly, they underlie, in my hypothetical, clearly the underlying facts of the man reaching over with a gun, pulling the trigger, and killing a victim are raw facts. Clearly, in my hypothetical, they underlie the second-degree murder conviction.
Sure.
But the jury has acquitted on first-degree murder, meaning they have not found premeditation beyond a reasonable doubt. It seems to me that if we pursue the government's theory here, which is you can consider the facts surrounding the walking back in the plane, the showing the videos and all that, and then the judge can draw whatever inferences the judge thinks appropriate because the facts were properly before the jury on account of conviction, then the judge, in my hypothetical, would be able to find premeditation beyond by preponderance and sentence accordingly under the guidelines amendment. Is that your view?
I think that's right. I think that's right, Judge. Assuming I'm tracking your hypothetical.
And you don't think that that is what the commission was trying to avoid?
No, I think the commission understood that there's overlapping conduct, right? Especially in trials of this nature, where these different counts rely on the same factual instances to prove the different counts.
I guess just from a gut instinct, it seems like my hypothetical would be the prototypical example of what the guidelines as amended were trying to avoid. So it seems hard then, if that is the government's view of how it would map out in my murder hypothetical, it's hard to accept how plausible the government's reading of the guideline is more
Your
generally.
Honor, I think hypotheticals are, I find, very difficult in this context. The commission understood that these situations are incredibly fact-intensive, and that's in large part because they only come up after a trial. And trials are all different, right? And evidence comes in different ways and weaves together differently. This is a very fact-intensive inquiry. I think what Judge Subramanian did here is he looked at the entire record, all 8 weeks. And imagine that being like a pizza, right? He's thinking about the entire trial as a pizza, all the facts, all the evidence adduced during that 8 weeks. But in considering the guidelines, he's not considering that whole pizza pie. He's considering a slice. And what's in that slice, it's what tends to prove the Mann Act. And that's why when he looks at the two specific incidents of coercion, those incidents are specifically tied to transportation. They're tied to the Mann Act.
And I guess that's where I'm suggesting that I don't know how to follow the pizza metaphor, so I won't try. That it's a little bit more analogous in my murder hypothetical, that the judge in my hypothetical can consider the physical actions of people, pointing the gun, shooting, the bullet hitting, the victim dying, but would not be able to consider the additional inference of premeditation. So you can still be considering the slice, if the slice is considered the evidence that was put before the jury, but I'm suggesting, or I'm positing the possibility that the guideline might limit the inferences that can be drawn to the extent those inferences are part of acquitted conduct, and not also inferences that would themselves constitute an element of the offense.
I think that's right. Again, I find it very difficult to think about these hypotheticals in the abstract. But I think here that slice of conduct that the judge considered, those two very narrow instances of transportation, I think undoubtedly tend to prove the Mann Act and also meet the requirements of the enhancement under the guidelines.
Can I ask you, I don't know, if I can change the subject a little bit. We've talked about any number of issues today. Can I ask you specifically about the leadership enhancement? One of the very specific questions we were talking about with your colleague on the other side was whether, as the government submits, there are at an irreducible minimum 5 criminally responsible participants in the Mann Act. And the government, as I understood your brief, said, well, there's Mr. Combs, number one, there are the 2 victims.
That's right.
The
Cassie and Jane, yes.
Cassie and Jane, so we're up to 3, and the government posited that the 2 escorts who were transported across state lines.
No, that's
not
slightly
what you argued?
inaccurate. Yeah, it's.
So why don't you clarify?
Of course. The 5 criminally liable participants, besides Mr. Combs,
Yeah.
are, as you said, Jane and Cassie, the 2
Right.
victims. And then 2 of the owners of an escort service.
Oh, the owners of the escort
They weren't escorts
service.
themselves, but they were owners of the service.
I'm sorry,
Who
I-
facilitated the transport of escorts who worked for that service.
Oh,
And
I see.
then-
And so your argument is that because they were involved in the transportation, and obviously, in your view, the evidence showed that this whole thing was clearly designed for prostitution.
That's right.
You're up to 5.
That's right.
If we
But-
were to agree with you on that point, does that make the whole question of acquitted conduct with respect to the leadership enhancement go away?
Yes, Your Honor, and I believe it could go away in another independent way, which is that the conduct was otherwise extensive, which is another prong of the leadership enhancement, and I don't think that the defendant even challenges that in his reply. So the leadership enhancement is met in both of those ways. With respect to,
Were those, remind me, and I should know this, and I don't recall, did the government present arguments that the escorts and their employers were members of the alleged racketeering enterprise?
no, Your
or
Honor,
conspiracy?
the only individual that the government identified as a criminally responsible participant for the purposes of the leadership enhancement was Christina Coram, who was an employee of Mr. Combs and who was
No,
alleged.
my question was about, in terms of when you argued the RICO conspiracy count
Yes.
to the jury, did you argue that the escorts or their employers were members
No.
of the RICO conspiracy?
No.
So I take it your argument would be that to the extent the district judge could permissibly consider the escorts and their employers, there would have been no overlap at all with acquitted conduct. That would be
Exactly.
your argument.
Exactly, Your Honor.
And then can you remind us who the judge said, I know I have this here, who the judge said were participants?
Who were criminally liable participants?
For the purposes of the increase, right?
Yes.
It's
James and Collins?
Ventura,
Ventura,
Doe,
Jane,
Coram.
Combs, Coram, who was the only employee.
And then James and Bridget Collins.
Bridget Creshover Collins, yes.
Those are the two
Those are the two
employers. So if
escort
we
employers.
knock out, if we were to say to drop out quorum,
That's right. You still have
in your
five
view, you're still left
participants.
with 5.
That's right.
And that's, okay.
And that meets the enhancement. That's
And then
right.
he also said the services of numerous outsiders that were peculiar and necessary to defense.
That's right, and that is to say.
But some of whom he included as, among that number, his assistants.
That's right, but the assistants were not alleged to have been part of the racketeering enterprise. So that is, like I said, that's another way to support the application of the leadership enhancement in that case, without even touching acquitted conduct or potential acquitted conduct. You know, with respect to the 3553A factors, you touched on this briefly with my colleague, but as Judge, you pointed out, the case law is binding that under the 3553A,
speech that I do in all death penalty cases. Plus, I normally don't instruct them on the death penalty at this phase. However, in this case, I am going to give a preliminary instruction because, unlike my normal practice, I am going to break down the people that can serve into smaller groups for death penalty voir dire. And the initial instruction on those jurors normally takes a while because I know I have a long speech I have to give. The state normally gives a relatively long speech, and then the defendants can give whatever speech they would like to. And I don't want to have to repeat that every morning during voir dire of the penalty phase, which would be phase 2, because it just sucks up time. So I'm going to give my preliminary instruction on the death penalty. I will then allow the state to give a preliminary instruction. You all can give a preliminary statement if you wish. And then what I will do is I will then ask the jurors 2 separate questions. I'm going to ask them first to raise their hand if they're going to claim a hardship for while they cannot serve. And then I'm going to read a statement, and I need to get an agreed to factual basis from you all to read to the jury and ask them if they think they know anything about this case. I will probably, so for those individuals that raise their hand as to knowledge about the case, pre-trial publicity, I will do individual voir dire, and we'll do that first. We'll bring them in one at a time. For those that are claiming a hardship without pre-trial publicity, I will do those in groups. So I'll bring them in, probably have enough to seat in the first row of the audience, and then I will ask them the initial question as far as what their purported hardship is. And then I will allow each of you, if you wish, to do any follow-up questions. And then once all of those individuals have been questioned, then we will determine who can be excused. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So because you may want to rehabilitate them, I don't know. Okay. So the individuals who do not raise their hand at all, who don't know anything about the case and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right. So I am well aware of the number of peremptories, 40 total for defense, 40 for the state. So I'm hopeful that we will have, at least 150 come back for the final phase. We'll see. So this is just going to be a situation where as we go along, we will see how things are going. All right. So then if I get, let's say, more than 30 people who can come back the week 2, I'll push some to Tuesday. And then same thing, Thursday people will come back either Tuesday, Wednesday. Friday people that come back will come back Thursday or Friday. I won't know until I know what the numbers are, exactly what day they're going to come back. But just so you all know, it will be smaller panels, week 2, 30 to 40, just on death penalty. Okay. So Mr. Hernandez, is that a long-winded way of answering your question? Okay.
Judge, one question I have.
Sure.
The statement that the court's going to allow defense and state to make after your initial inquiries, what is the court anticipating with regard to that statement?
I'm assuming it's just pretty generic, just enough to trigger their memories. And we had a statement in the Alicia Andrews case that you all may or may not agree to, but it's kind of just basic parameters, things like this was a shooting that occurred up near USF on the date in question, and that it involved an allegation of potential gang involvement, and the victim was Charles Jones, known by his rapper name Julio Fulio, something like that.
And that's the statement that's going to be given by the court.
Correct.
What about the statement that you're referring to, that you would allow both the state and defendant?
That is the statement. No. The statement that
I'm talking about something that we are allowed to get up and do with that.
Yeah, no. No. There's two separate, I guess, statements. So the first one is one I would make in anticipation of my question about pretrial publicity. Okay. The next would be with regards to the death penalty information. And again, just from experience, Mr. Harmon has a script that he uses, and I don't believe in any of the cases I've done, defense actually said anything in addition, really. So you don't have to. I'm just letting you know that if you would like to stand up and just give because I'm allowing the state the chance to do it, to give a general instruction or information about death penalty qualification.
Fine, Judge. I need some clarity.
Yeah, it's just, I don't think any defense attorney has ever done it, and you don't have to. I'm just giving you the opportunity if you so wish.
Understood.
Okay, but normally between myself and Mr. Harmon, we cover pretty much everything. So, okay. And I'm also considering, and you guys tell me if you think it's a good idea or a bad idea. Once we get our jury picked, so this would not include next week, I'm considering giving the jury Fridays off. Mr. Sonardi gave me the thumbs up. You guys... I'm hoping that will be some sweetener to encourage people to want to volunteer to serve, since they know they at least will get Fridays off to handle their personal affairs or do what they need to do. But you all tell me.
Certainly always a good situation with regard to getting people to want to serve, and certainly allowing lawyers to do what they do. I don't know if the state has any indication. We haven't gotten a final witness list yet, which of course no one's obligated to do.
Right.
But to the extent, would the state have any indication as to what they think their case in chief, short of catastrophe, might take? I'm just more looking about, quite frankly, Judge, my calendar beyond
Sure.
15th. And there are some challenges there, and I need to know whether the state has any idea as to what they might.
So let me ask you this. So let's just talk about this a little bit. So hopefully, if everything goes smoothly, jury selection will be concluded by Tuesday, April 21st. Okay, that's my goal. I will be working very hard towards that goal. That means we do opening statements on the 22nd and begin with the presentation of the evidence, the 22nd and the 23rd. I can tell you right now, we will not have court on the 24th of April. So then the guilt phase portion would begin again April 27th. And we'd go through that week. And then depending upon things, and depending upon if there's a finding of guilt as to first-degree murder, penalty phase would begin May 4th or thereabouts, and last most of that week.
Does that comport particularly with what the state would anticipate from a case in chief standpoint? And again, I'm asking a question that they may not have the answer to, Judge. I'm just inquiring.
I think that in general terms it does. I know that this trial will be somewhat longer because there's more attorneys, but
Sure.
I think that that's a good general guideline.
So I'm trying to remember how many days did it take us in the Andrews case? 7? Well, remember we picked a jury though.
Correct. Yeah.
Starting, I can't remember, did we start Wednesday or Monday? I think it was Monday. Did we start Monday?
Judge, I don't remember.
Yeah, I
I'll
don't
have to go back and look.
either. Let me look. I don't know. What month even was that? Who could even?
It came in on October, on Halloween.
Okay, let me look.
5 years ago now?
Yeah, it feels like it.
Halloween.
Yes, it was. Yes, it was. Okay, well, I don't have that with me. So anyway,
That gives me a much better indication, Judge, without nailing anybody down, that actually answers my inquiry. Truthfully.
yeah, it took us a couple days to pick the jury in that case. It took, 2 to 3 days to get the jury picked. So it took us, I'm going to say, about 7 work days to get it tried. So maybe 8 or 9, just because we have more lawyers, but I would say 8 or 9 for guilt phase portion of the trial.
There may be a few more witnesses in this case.
Okay.
And probably a little more extensive testimony from those witnesses. Because I think there were some limitations
Sure.
in the Andrews case that probably don't exist here.
Sure. Okay. So, yes.
I guess along those lines, I think it's safe to say that I should, if there is a need for a penalty phase, I shouldn't have any witnesses ready in April. It should be May.
Yeah, it'd be May. I would say May 4th at the earliest. May 4th at the earliest. And I'm going to ask Mr. Hernandez, what's your absolute need to be done by date? Mr. Gonzalez, what's your absolute, and Mr. Hernandez, what's your absolute need to be done by date?
Judge, preferably the 18th or 19th of May. I don't know whether any of those days fall on the weekend, but.
Yeah, we'll be done by then. Okay. Mr. Sonardi, what about you? Any? Okay. Mr. Wise?
Your Honor, my only, sounds like, I'm on the same boat as Mr. Gonzalez. I had everything blocked off for May 15th, so starting May 8th, I had.
Yeah, we'll be done by then. We'll be done by May 15th. Okay, we will. And Ms. Petratus? Okay, yeah, we will. So, okay. Very good. So now that we've discussed the calendar, so at this point, I won't commit to the jury taking Fridays off. I will tell them Friday, April 24th for sure. And that if we're making good progress and it looks like I can give them a Friday off, then I will. But at this point, I'm going to be conservative because it's more important that we, the trial gets completed in a timely fashion. So, okay. Okay, Ms. Ismer. Yep.
Yeah, the CD chart, he has to tell to these guys. That's what it looks like. And Connie made the sheet in the back. You want me to just make a copy and give it to
That'd be great. Excellent. Okay, so this would be, the state is displaying, this is a still shot, blood on my Pradas, and that is Goudaze, which I believe is a name that Mr. Chance goes by, correct?
Yes, Your Honor.
Okay, and
Did y'all hear how she tried to pronounce his name? Goudaze. I think it's Goudaze, but it's funny trying to hear her pronounce that stuff. She said Goudaze. I think it's Goudaze, but you're funny.
and when was this distributed or?
I'd have to look back at the original motion for the date.
Okay, or posted? September 2023? Okay,
The 8th of 2023.
okay. So this is the one you object to,
This specific picture.
this specific
And
picture?
I'll say, we're not going to be objecting to Detective Mead or someone who knows him saying that is Mr. Chance. And we're not going to be objecting that is the name, the top Goudaze that he uses. But and we're not going to be objecting to this, but based on your ruling. The other two pictures, which is him wearing a 23 chain,
Okay.
shown in this picture. So I'm not going to object to this and then try to jam up the state later, but it's this specific picture. I don't think it's necessary to show blood on my product.
Well, yeah, so what if they just redacted blood on my Pradas?
Well, I would say that what he's doing in that picture could be interpreted negatively, whereas they're just trying to show him wearing the 23 chain in the music video. I don't want to say stipulate, but I'm not going to object to suggesting this was a video he made on September 8th, 2023. That is Mr. Chance, and he's wearing, it can be very obvious in the other two pictures, a chain, number 23 on it.
Yeah, well, it looks like, just for the record, it looks like he's maybe mimicking shooting a gun or shotgun or something. That's what he appears to be doing. So why do you need the title Blood on My Pradas?
All of the other exhibits from YouTube include the title and the account name for the individual who posted them. So to redact only this screenshot or only this defendant's music video, which indicates obviously still images for at least this exhibit of the defendant wearing his gang chains or talking about offenses or crimes that are linked back to the gang that he's affiliated with, I think it causes a discrepancy in what evidence is being presented. The defendant would, in this instance, be the only person whose music video title isn't also displayed alongside of all of the other videos which are establishing his gang enhancement.
All right, let me see the other still shots, just to make sure, for the record.
This is still shot 1 and still shot number 2. Both of the redactions removed the guns or body parts that were depicted.
Okay. And this is going towards the gang enhancement, correct?
That's correct, Your Honor.
Okay.
We'll seek testimony as to the lyrics because in playing the video, obviously, we knew the defense would have an objection to all of the content, which is why we redacted to these specific images.
Okay, very good. All right. So based upon the state stipulation to limit this exhibit to the 3 screenshots, I'm going to overrule or deny the motion in limine, followed by Isaiah Chance. I find that the evidence the state seeks to admit that its probative value outweighs any prejudicial effect. Okay, and next would be the motions I have a copy of. Defendant Rashad Murphy's motion in limine as to Robert Howard.
Judge, this is an all-encompassing motion, as the court can see, regarding several different areas. And it is buttressed on the statement provided and ultimately made confidential, made by Mr. Howard in August of 2025, as well as his deposition taken on February 4th, 2026. It seeks to limit, based on what I believe is hearsay, improper speculation by Mr. Howard, and pre-conspiratorial statements that are attributed to other defendants. Certainly understanding the court's ruling with regard to severance, I still have concerns about evidence that may in fact be admissible against one defendant and not admissible against others. As it relates to the hearsay statements, Your Honor, any statements that Mr. Howard alleges Mr. Murphy made as it relates to threats to him or his family are statements that he heard from other individuals. And that's based on his testimony at both his statement and his deposition. He talks about things allegedly stated by Mr. Murphy that were told to him by others, and goes on to suggest that in his alleged conversations with Mr. Murphy on multiple occasions, he didn't consider those conversations either threatening nor friendly. So certainly buttressing that feeling and that speculation and that statement being what he's been told by others.
Okay, so maybe it'd be helpful if we just went through these statements. You've broken out the different statements per category, right?
Yes, sir.
So let's just start with the hearsay statements beginning at page 2 of your motion. Specifically, you allege that Mr. Howard testified that he heard from other individuals that Murphy had made threats.
That's correct.
Okay. State, were you intending to elicit that from Mr. Howard?
Is this as to paragraph number 5, Your Honor?
It is.
No objection as to statements he heard from other individuals, only statements that Mr. Howard heard directly from Rashad Murphy would be offered.
Okay, so as to paragraph 5, it's granted. And then paragraph 6, Mr. Howard further clarified that he spoke with Rashad Murphy on multiple occasions. Oh, so that's
That's just
different.
providing context.
Okay. And then the next would be paragraph 7. Mr. Howard testified, subparagraph A, that he communicated with Isaiah Chance, who told him that Murphy was hot about Adam's murder. State, are you seeking to elicit this from Mr. Howard?
Yes, Your Honor. Any statements that were made by any unaffiliated party with the case, the victim, as listed in this motion, the state's not seeking to introduce. But statements made by the defendant or co-defendants in this case, the state is seeking to introduce. Not as statements of hearsay, they're not being offered for their truth, but to establish intent and premeditation and motive in this case.
Okay.
Judge, it also goes to admissibility statements as it relates to Mr. Murphy. And the argument would be it's not a co-conspirator statement based on when it is said. And in fact, I think the state would have to establish when that statement was made to determine whether or not it was in the course or in furtherance of any conspiracy. And I don't think they can do that.
So state what your argument is as far as why this is admissible if the statement was made not during the timeframes of the purported conspiracy.
Because Mr. Gonzalez's argument reverts back to a co-conspirator admission, which is a hearsay exception. The state's position is that it's not being offered as hearsay. So understanding the limitations of a co-conspirator hearsay statement, we're not offering it as a statement of hearsay in the case. It is strictly being offered as proof of other elements, so knowledge, intent, premeditation. The state has filed in its initial response to the court and has had previously provided to the court the case law on this before Mr. Gonzalez's motion. So the March 5th response gave the case law for all of the reasons that the state sought to introduce each of these statements, Your Honor, and we would rely on that case.
Okay, I'll come back.
Mr. Howard can't testify what Mr. Chance told him about Mr. Murphy. And I don't think it's admissible based on any theory of motive.
Isn't it double hearsay?
The statements that Mr. Murphy was hot are statements that are made from Mr. Chance to Robert Howard telephonically. Is that what are these the ones you're referring to, Mr. Gonzalez?
Yes.
Okay. And so the state's not off, again, the state would just reserve the same exact basis as for why the evidence is being offered. It's not being offered for its truth. So continuing to indicate that because it's an out-of-court statement, it invokes co-conspirator hearsay when the basis for why the state is offering the item of evidence is strictly the defendant's knowledge of what was to occur, the premeditation of the act of what is to occur, because the context of that conversation is in telling the person listening, which is the witness, Mr. Howard, to be careful, essentially, when he goes to Tampa. These things are, in context, being offered for a different purpose than a hearsay or co-conspirator statement or admission.
Let me think about it. Okay, the next one, subparagraph B of 7, Howard testified that Charles Jones told him to watch out for Murphy because of Murphy's purported threats.
No objection from the state.
Okay, that one's granted. Subsection C of paragraph 7, Howard testified that he heard rumors that Murphy was riding past the prison that Howard was at.
No objection from the state.
Okay, granted as to 7C. Okay. So I think that takes care of all of the statements identified in your subsection under hearsay. Is that correct?
That's correct.
Okay, moving on to opinions, speculation, beginning at page 3, paragraph 13. Howard testified about a Bill Belichick and Tom Brady social media post, which he attributed to Isaiah Chance following the murder. Howard speculated that the post referred to Charles Jones because Brady is the GOAT of football and Charles Jones is the GOAT of rap music. State.
The witness's impression or his specific observations, I don't expect he'll be testifying about what Isaiah Chance meant, but only about what he understood the post to be.
Judge, I think that's inadmissible. It's asking Mr. Howard to speculate and give his opinion as to what he thinks something might mean.
Well, what was the actual, what was the actual, what was it that was posted and what was the content of the post?
A photograph, so it was not a part of our hearsay argument that we previously provided to the court of Bill Belichick, a coach of the New England Patriots team. There were consistent photographs of either Tom Brady or Bill Belichick posted by the defendants.
So Isaiah Chance posts photos of Bill Belichick and Tom Brady.
Yes.
Is there any words attached to the post or just the post?
No words on the Bill Belichick photo. I think hands up. I'm not sure how to describe the emoji, but an emoji on the photograph, but not words associated to that post. There were other Bill Belichick posts in the co-defendant's devices, so I'd have to pull them up to check for language. But to my knowledge, having discussed that with the defense attorneys, I didn't believe there was any other language that was on those photos.
And this was post-murder of Charles Jones?
Correct. These were posted, some within minutes and some within the first couple of hours after the homicide.
Just for context too, Judge, some people may think Tom Brady is the GOAT of football. That's your opinion. Some people may think that Charles Jones is the GOAT of rappers, and that's somebody's opinion. And I think that that needs to be considered in its totality along.
Well, yeah, I'm just trying to figure. And so what's it relevant to?
I believe if I recall correctly, the specific testimony that was provided by that witness in trial 1 was that while he was on scene of the homicide within minutes, he logged onto social media, saw that post, and immediately knew that the poster had done it. Like that was the testimony that was provided. There was nothing specific as to the defendant's state of mind or what the intention behind posting the photo was. It was whatever the witness had observed on scene in that moment as he was checking social media and before they were able to notify the family or the media having arrived. That was the testimony that was received, and that's what we anticipate will be the same in this trial.
Okay. So how quickly did the post happen after the homicide occurred?
I have to check my timeline, Judge, because there are several across all of the devices that we have received. I say a Chance's post was on June 23rd at 6:13 a.m.
So is that the morning of the homicide?
Yes, Your Honor.
Before?
No, this is just after the homicide. So the homicide occurs about 5 a.m.
On June 23rd. So this is right after.
This was the
Okay. 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 So I'm going to deny the motion in limine as to the social media post. However, grant it as to any speculation on the part of Mr. Howard as to what Mr. Chance meant.
Judge, although I can't be positive, I looked at Mr. Petrini's screenshot, and it looks like the post was made on 6:13 a.m., and I think the murder occurred at 4:37 or 4:38, so it's a couple hours,
Yeah.
hour and a half, 2 hours, somewhere in that neighborhood.
Right. So I've denied paragraph 13 as to the post itself, but granted it as to any interpretation by Mr. Howard as to what Mr. Chance meant by it. Okay, next up, paragraph 14. Mr. Howard testified that Rashad Murphy texted him after the murder stating, "I forgive you."
And Judge, what we're talking about is not a text that the jury would be viewing. It would be Mr. Howard's testimony that Mr. Murphy texted him and said, "I forgive you," and then speculating that that is a result of Mr. Howard having been convicted of the murder of Joe Rod Adams in 2018.
Okay, State, are you going to seek to admit this?
We are seeking to admit it, Your Honor, for the same basis, the motive and intent behind the defendant having committed this crime. The testimony from Mr. Howard is that that message comes in within either the same day or the next day. I believe it's testimony at depo at trial that he receives from the defendant.
He doesn't know when he got it, really, at the end of the day, although he does limit it to within a day.
Okay, I'm going to deny as to paragraph 14, but granted as to any speculation on the part of Mr. Howard. Okay, paragraph 15, Mr. Howard further testified that, is that Rashad Murphy?
Yes.
Okay, spoke with him after the murder and that the two discussed their respective whereabouts. Mr. Howard testified that Rashad Murphy stated he was in front of Julio's car. Okay.
Yes, Judge. Mr. Howard speculated that what Mr. Murphy meant is that he was present at the shooting. But actually, Howard admitted that Murphy never stated he was present at the scene, nor that he participated in the murder. But the context of what he was alleged to have said was he was in front of Julio's car. He previously testified during his statement that in talking about the same discussion that Mr. Murphy alleged he was present at the Truth nightclub, not at the scene of the murder. And so obviously the inconsistencies are something that can be
sussed out in cross-examination, yes.
But as it relates to him testifying that Mr. Murphy was in front of Julio's car and then testifying that what Mr. Murphy meant was that he was at the murder should be limited.
My only concern with this one is it gets a little bit convoluted. It is a part of the conversation that Mr. Howard is indicating that he's having with the defendant, whereas the defendant is completely describing the scene. You had your head on a swivel. You were looking here and there at each of the locations. And so certainly the state is seeking to admit it as identification, but I think this one, if the court is inclined as it relates to the speculation, maybe one that we ask if the court would allow that we wait until we get to that point in the presentation of the evidence. I don't know how we can slice that up, if that makes sense, based on the context of the full statement they gave for that.
I just don't want during the course of direct testimony for Mr. Howard
To draw an opinion.
to speculate that what Mr. Murphy's talking about is he was in front of the car during the course of that murder.
Okay. So again, I'll deny paragraph 14. It's admissible. But again, Mr. Howard cannot draw opinions. He can only testify as to what was said. And then that's why we have closing arguments, and you guys can argue the meaning.
Did you say 14 and 15?
I'm at 15, yeah. All right, paragraph 16, Howard also testified that Rashad Murphy later told him, "It is all good, we good now." State, are you intending to introduce that statement into evidence?
Yes, Your Honor, but no objection as to limiting without speculation on the part of the witness.
Okay, very much, very good. Then the paragraph 16 will be denied, but again, no speculation or opinion as to what Mr. Rashad Murphy meant. Okay, paragraph 17, Howard opined that social media posts referencing Don Julio were intended to disrespect toward Jones because Julio appears in Jones' Instagram handle. State, were you intending to solicit that opinion from Mr. Howard?
Not as it relates to disrespect, as it relates to Don Julio or Julio. If he has specific knowledge in this case about the fact that Julio and Don Julio are linked because of his relationship to the case, I would ask that that be admissible.
And Judge, I guess, just for clarification, Mr. Howard's not going to be testifying to his opinion that it was done in a manner of disrespect.
Right, you're just going to say that
I saw bottles of Don Julio.
and to me, and based upon my knowledge and experience or whatever it may be, that is a reference to Charles Jones, right?
Understood.
Okay, so it's denied with that understanding. Again, as to paragraph 17, Mr. Howard can testify as to the facts or what he knows, but he can't speculate on the intention of the poster. Okay.
Seeing Judge of those that.
Okay, moving on to co-defendant statements.
And again, I'm going to preface before the state goes in, the court goes in further. Again, understanding the court has ruled.
Right.
As it relates to severance. I just want the record to be very clear.
Yes, you're not.
Have concerns.
Yeah, you're not waiving any objections that you've previously made. Okay, let's see. Paragraph 25, Robert Howard stated that he had multiple conversations with Isaiah Chance in which Chance expressed his dislike for Charles Jones. He emphasized that Chance and Jones engaged in multiple social media arguments in which they disrespected one another. Are you going to be attempting to admit this evidence via Mr. Howard?
Yes, Your Honor, all of it will come in through the experts, except for one interaction which occurred between Chance and Charles Jones that Mr. Howard was the primary witness to. Otherwise, law enforcement witnessed the exchanges.
And certainly my argument has to be, notwithstanding other motions and other rulings, is that Mr. Howard not testified to that. It's coming in through a gang expert.
Right.
And as it relates to his direct interaction in seeing something occur, then of course I don't have a legal objection to that.
Okay, so it's a paragraph 25. It's sort of a general argument. I'm going to deny the motion in limine as paragraph 25. However, you reserve the right to make contemporaneous objections at the time of trial. So if something's coming in through the gang expert, then at that time, if you want to raise an objection, you can, but generally speaking, it's denied. Okay, and then there's a more specific statement at paragraph 26. According to Robert Howard, Isaiah Chance allegedly stated that Charles Jones was going to die. Do you seek to admit this through Mr. Howard?
We seek to admit the conversations that occurred within the time frame of the conspiracy that's listed as it relates to these conversations, but not from before that. The motion, though, is not clear because there were conversations which occurred outside of that time frame discussing the same type of comments or threatening remarks. Mr. Howard and Mr. Chance had some type of relationship which was jovial enough for them to speak often about this issue, but there are specific exchanges which occur which indicates that there are threats on the victim's life and for Mr. Howard to kind of avoid that danger when they come to Tampa. We know that's within the time frame, regardless of whatever testimony Mr. Howard was able to give in his deposition about the specific dates, because they reference the posts that Mr. Jones made to social media of the flyers for the events that were occurring in Tampa, and that occurred on June 14th of 2024.
Judge, I would only point out that certainly we have to rely on Mr. Howard's testimony as to when he heard these things. We have no other way.
I know.
And to the extent that he testifies under oath that he believed that it occurred at the end of 2023 or beginning of 2024, it would have been long before any conspiratorial time frame. And again, as it relates to Mr. Chance, that argument can be had in another way. So generally, it occurring within late 2023 or early 2024 is a problem. And again, I would reiterate, as it relates to evidence that the jury is going to hear that they can consider against Mr. Murphy, it's a problem.
Okay, so there's two separate things going on here. So let's first discuss, if I'm hearing you correctly state, you're only intending to seek these conversations between Mr. Chance and Mr. Howard during the time frame of the conspiracy, correct?
Correct. The content of the conversations during that time frame.
Okay.
Otherwise, it is just generally the relationship between the two. Did you speak on the phone previously?
Right.
What was your relationship, but not the content?
Not the, okay, so with that understanding, that's what the state is saying. So it would appear then as to paragraph 26 and 27, because Mr. Gonzalez is alleging that Mr. Howard stated that this specific comment that Charles Jones was going to die occurred sometime at the end of 2023 or the beginning of 2024, which would be outside of your conspiracy timeframes, correct?
Agreed, Your Honor.
Okay, so as to specifically paragraph 26, that will be granted. Paragraph 28, Howard further testified that the ongoing dispute between Charles Jones and Isaiah Chance had escalated to the point that if they would have seen each other, they probably would have wanted to do something to each other. That appears to be Mr. Howard speculating. Are you going to seek to introduce that?
No, Your Honor.
Okay, so granted as to paragraph 28 is that statement. Yep. Well, 27 is not, it's just a historical fact. Okay.
The finding, though, Your Honor, if I may, as to 27 and 28, they really should be together because the other remarks about Mr. Jones dying do occur within our conspiracy time period. So I don't want the record to be unclear. There are several remarks made within our conspiracy.
Right. So, okay. So as to 27, it's granted as to anything outside of the timeframes of the conspiracy, denied as to any statements made during the time frame of the conspiracy.
And certainly, Judge, subject to later potential objections, I would certainly having no reason to dispute what Ms. Isber saying. The state's going to have to, in order to admit those statements, lay a foundation as to when they occurred and whether they occurred within the conspiratorial timeframe. Anything that Mr. Howard can't tell us when it happened, if that turns out to be the case, certainly I think should be excluded.
Okay. Yeah. So again, subject to contemporaneous objections at the time. But the appropriate foundation needs to be laid. Okay, paragraph 29. According to Mr. Howard, Davion Murphy confronted him regarding Howard's involvement in Adam's murder and stated, "Bro, I'm going to catch up with you. I'm going to deal with you." This allegedly occurred at least 6 years prior to the conspiracy. State, are you seeking to admit this?
We are seeking to admit it, Your Honor, for identification purposes and for motive evidence. These statements were made specifically as a part of this quote as well, following Mr. Murphy's mention that Spaz, or the person that Mr. Howard was incarcerated for killing at the time, was his relative. And so he's shouting that at Mr. Howard at the time. Mr. Howard also being present with the victim in that parking lot on this evening would be a basis as to why we're seeking to introduce this.
Okay.
It occurred allegedly 6 years prior to Mr. Jones' murder. Number one, again, just so we're clear, there is problem number one, its admission of a statement 6 years earlier and how it might affect the jury as it relates to Rashad Murphy, since we are not severed, number one. And number two, it again falls, based on the prior arguments, far outside of the conspiratorial time frame.
All right, let me think about that one. Reserve ruling. Okay. 30 is just a statement of law, paragraph 30.
One more thing, Judge.
Sure.
Also, as it relates to the fact that there are two Murphys here, and these Murphys are cousins.
Right.
I think there's a even more complex and complicated issue in allowing that statement to come in and how the jury may perceive it, and its prejudicial effect outweighing any probative value.
Okay, thank you. I reserve ruling. 30, paragraph 31, Howard attributes several statements to co-defendant
Can we
Isaiah
talk about,
Chance.
Judge?
We've already discussed it. Okay, same ruling. 32 is just a legal
Context.
argument. Okay. I think that takes care of
It
your
does,
motion.
Judge.
Okay, so I'm going to think about
7A.
7A and then paragraph 29. Okay, I'll let you guys know.
Thank you, Your Honor.
Sure. And again, when we talk about the severance issue, again, just to clarify, we don't have a Bruton problem here. And then the only issue would be if there's evidence that would, quote, improperly influence, close quote, the jury, with evidence that would be against one or more co-defendant and not all of them, which is kind of an amorphous standard. So it's kind of beauty in the eye of the beholder. So that would be the determination whether that evidence would rise to the level of improperly influencing the jury.
And Judge, it goes without saying that the state would not be opposed to a limiting instruction from this court, specifically with instructions to the jury as to which defendant the evidence applies to at the time when we introduce those portions.
Sure, I understand. And it is a different, I did find really an abundance of caution, the two statements or the two text messages that the state agreed not to introduce were I think it was 2023, a set of text message exchanges between Isaiah Chance and Alicia Andrews. While those, in my opinion, are admissible as to Ms. Andrews and Mr. Chance, it does predate the conspiracy. So in abundance of caution, those should not come in. The state agreed. The other one was, I guess, the celebratory comment made by Mr. I think Davion Murphy that was sent to Sean.
Judge, I don't believe we know which Murphy
Right.
specifically sent it, but it's
Okay.
signed Murphy.
Right. So for those reasons, and including the fact it was post-conspiracy and an abundance of caution, I didn't think it should come in as at a joint trial, and the state agreed. These statements that are made by the defendants during the conspiracy timeframe in particular are distinguishable from those that I thought should be excluded in an abundance of caution. As I'm trying to not tiptoe close to, quote, improperly influencing, close quote, the jury, as that phrase has been utilized in specifically second DCA precedent.
Judge, and just so the record is notwithstanding the court's ruling, as it relates to the celebratory messages that are not coming in, there was testimony from Detective Ramos that, in fact, the witnesses he spoke to indicated that they didn't know Rashad Murphy. It was Davion Murphy that they were aware of, and that that's who they believe the text messages were sent by.
Right. So we had two issues with those messages. One, it was post-conspiracy, and two, the foundation of who actually sent it, which of the Murphys is less than crystal clear. Right? Right. Okay. 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 So, and then the other motion was with regards to the Andrews verdict during penalty phase.
Yes, Mr. Harmon filed that, I believe yesterday afternoon. He is out today, but I said that I could cover it. Do you want to handle that now, or I don't know if you received it or not?
If I received it, I haven't seen a copy yet. So do you have a copy I can look at? Okay, thank you.
And Judge, we did briefly touch upon it. I believe that Mr. Petratus had filed a judicial notice of the verdict of Alicia Andrews, and we had spoken, and I think that you had previously said that obviously would not come in during the guilt phase, that it did not have a relevance. I think that Mr. Petratus had made some indication that he thought it might be relevant for penalty phase. And I think that is Mr. Harmon's objection. He filed a formal motion in limine objecting to that, as it would be improper and have no bearing or relevance to the jury's decision with regards to mitigation. It's improper character. There's no reason or way to tell this jury why the jury in Alicia Andrews made the decision that it did. There could be a myriad of reasons, including mercy, jury nullification. We don't know why they made the decision that they did. So what happens in one defendant's trial, verdict, or sentence doesn't have a bearing, or should not have a bearing in the current defendant's penalty phase. And so that was the basis of his motion.
Well, and it looks like there may be precedent, United States Supreme Court opinion, Lockett, right?
Yes, there was some case law that he filed as well.
Okay.
In support of his position.
Okay, so I tell you what, I'm going to take it under advisement. Let me take a look at this Lockett case, and then Mr. Petratus, do you have any additional, or does anyone have any additional case law, or do they want a chance to submit it?
I don't have any additional case law right now.
Okay, so I tell you what, I'm going to take it under advisement. I'm going to look at Lockett.
Sure. Could we have a chance?
Yep. How much time do you need?
Briefly address something on that.
Sure.
I just looked out the motion this morning, but I think we're just dealing with sentence, not involvement, correct? Because
Correct.
I think that Alicia Andrews' involvement in a penalty phase can be compared to another particular defendant's involvement. But I'm trying to make sure that the state's motion is only dealing with sentence, not Alicia Andrews' actual involvement in this case.
Well, it says specifically in the motion, the subject matter in question is any argument comparing or regarding the verdict rendered by the jury to the Alicia Andrews case to the defendants, or otherwise arguing that fact as mitigation.
The point I'm making is that I think that her involvement, any defendant's involvement, which can be a problem when you have multiple defendants, but the involvement of one defendant versus another can be relevant for a penalty phase.
Okay.
Not verdict, as in the Andrews case maybe, or the sentence, but certainly one person can be more culpable than the other. And again, the problem is suggesting that maybe one defendant should get life and another defendant should get death.
Okay, so I'm going to give you guys a chance to research the issue and submit case law. Okay, so how much time do you need?
At least a week, Your Honor.
Sure. Okay, so I tell you what, I will give you guys until Friday, April 10th to submit any case law to me on this topic. Okay. Any other motions we need to discuss?
Your Honor, as a part of the state's response from this morning, the court had previously asked the parties to submit to the state any additional YouTube videos they intended to use or additional items of evidence that the court needed to consider. So the state did also address those things. I can tell the court that I've reviewed the videos that were provided, and the state does have some objections to those videos. I know Mr. Chance, on behalf of Mr. Chance, that there were 4 videos provided, and on behalf of Mr. Murphy, there were 4 videos provided.
Davion.
Davion Murphy. I will defer to the court as to how we address those, or if the court just wants to hear the state's objections as to those.
But do you have them identified?
Yes, and with a link in the event that the court or the other parties wish to see them as well in the motion.
But you haven't filed a motion in limine?
I have filed motions.
You have?
Yes, Your Honor.
Okay.
I filed this morning because we received the defense to this motion in limine on their videos yesterday.
Okay. Well, can I take a look at your motion?
May I approach? Your Honor?
Sure.
I kind of just emailed the judge, she wants to straight this with you.
Okay. Okay, all right, so according to this motion, the state wishes to keep out, as to Isaiah Chance, a video titled List of Dead Ops that was posted on YouTube. A block party invasion went to Young and Ace block. It's a YouTube video. 3, God Don't Know by Julio Fulio. And number 4, Demigod by Julio Fulio. So are any of the defendants seeking to actually introduce these, and why?
These would be, these were said somewhat in abundance of caution, but these would be rebuttal, depending on what is testified to by some of the state's experts, the gang experts.
I see.
And it would be authenticated through that expert, if at all. It may not be necessary depending on direct cross-examination. And possibly only if you need some still shots from some of these videos.
All right, so you're not intending to utilize these, and in your case in chief, seek to admit them in your case in chief. It would just be potentially as impeachment or rebuttal as to the testimony of the gang expert?
Correct, Your Honor, for a variety of reasons, based on gang certification and issues with Mr. Jones.
Okay, so then as to these 4 identified videos, I'm going to grant the motion without prejudice to revisit. If you think that you actually need to introduce them, we just need to talk about it before you do it.
Yes, Your Honor.
Okay? But generally speaking, the videos are not to be referenced or discussed in front of the jury until I've given permission for any party to do so. And then as to Davion Murphy, the videos listed are When I See You by Julio Fulio. Again, the List of Dead Ops. YouTube video Certified Killer by Julio Fulio and God Don't Know by Julio Fulio. And why is Mr. Murphy going to seek to introduce these, or what are you going to do with these?
Would be the same position as Mr. Chance becomes.
If you think they become relevant, then you would seek to introduce
That's
them.
correct. We'd ask the court just to,
But you're not going to be submitting them as you don't anticipate at this point as part of your case in chief.
correct.
Okay, so that'll be the same ruling. Generally speaking, these videos 1 through 4, as to Davion Murphy, the state's motion is granted, however, without prejudice to revisit. And during trial and defense, you just need to confirm with me ahead of time before you start showing them or discussing them in front of the jury.
That's fine.
Okay, very good. Then we've got unrelated officer conduct Counsel for Davian Murphy has filed a notice of intent to rely and listed a witness and records from the Jacksonville Sheriff's Office to include the personnel history of Detective Craig Griffin and Trey McCullough. Are you going to actually seek to utilize these records as impeachment?
Yes, I believe that's Mr. May's motion.
She filed a motion as to these?
Yeah, I thought that was what it was. Correct.
Well, because I don't have that motion in front of me. So did Ms. Tomei, did Davion Murphy file a motion in limine specifically to include this information?
She did not. She sent us an email with a notice of her intent to rely on the information, and she did file an amended discovery list with instructions that she would seek to introduce or admit the following videos and evidence, and then listed the witness as well.
Okay. So, Mr. Sonardi, is Ms. Tomei, is she handling this argument, this issue?
I was not aware that Mr. May was not going to be here. I'm really not in a position to argue that motion.
No, I understand. I honestly would like to see what we're talking about here, as far as what the actual evidence is. So,
We're not filing, Your Honor, but I do have 2 copies of the investigation history. I do not have copies of the civil lawsuits that were filed against the Jacksonville Sheriff's Office for the court because they were pretty lengthy, but I can provide these copies.
But I don't think that was actually filed.
okay. So here's what we need to do. Are you able to contact her this morning, Mr. Sonardi?
Right. I got her number on you. So.
Your Honor, if it's okay, I have warrant in Polk County if I could.
Yes, you're free to go. So I tell you what, let's do this, Mr. Sonardi, let's just take we'll recess as far as Davion Murphy, and I'll give you a chance to, because we're going to need to set another date, because I'm going to need to actually physically take a look at what these records are, and we need to have further discussion on this, and whoever needs to be able to argue the motion. So why don't you find out her availability for the remainder of this week and Monday and Tuesday of next week, so we can get that done. Are there any other issues as to Rashad Murphy, Sean Gathright, or Isaiah Chance?
You know, the only thing, and this may not be the time, but I know we were talking about with the deputies. They want to talk logistics as far as how we're going to plan on fitting everyone.
I was gonna bring that up, Jeff. There's a small army on the side of the fence.
It's only about half of us, I think.
Okay. Well,
He's gonna leave that up to us and the court staff.
yes.
Do you have anything you don't want? Because
No, I really don't. As long as you guys can get to the podium without having to create a distraction, that's all I care about. So
and certainly having ingress and egress
yeah,
without the staff being concerned about.
correct. So I do think anybody that's not going to be speaking on the record, okay, staff that's not going to be speaking on the record, do you want them in the well, or are they okay in the audience, or what do you think?
Judge, in previous experience, I could tell the court that for me personally, my investigator is critical.
Okay.
In a number of different ways in a trial this big.
Okay.
So I would suggest to you that I would need my investigator at council table.
Okay. So how many people total? You have yourself, Mr. Hernandez, your investigator. Who do you need at table in addition to your client?
Mr. Hernandez, myself, and the investigator.
Okay, so you need 4 people.
Correct.
Okay, Mr. Sonardi, how many people do you need at council table?
Five.
Honor, obviously, myself, I'd like to have my investigator, but it's possible that she could sit behind me, so she's not.
Okay. Could your investigator sit behind you, Mr. Gonzalez?
I'd rather not, Judge.
Okay.
I mean, unless it's a crisis situation, because he does work very closely, not only with me,
Okay.
but with Mr. Murphy.
Okay, so they want,
I would like Scotty Sinardi, the other.
yes, and Mr. DeLauder.
I don't know.
Your Honor, I'm considering I'm the smallest fish in the pond and the last one on the totem pole. I'll go wherever I need to facilitate. It'd be nice to be at the table.
Right.
But wherever I
Need be, we can throw you off the island into the audience, right? Okay. But 5, preferably in a perfect world. Okay, Mr. Wise?
Here we have Ms. Finkelstein, you may recall Mr. Mendez is third chair counsel as well. He's been here for some of the proceedings. And then I would like our investigators slash mitigation expert, at least during jury selection, if there is a definitive phase.
Okay, so 5
Yes.
people. Okay, Mr. Petratus?
5, Your Honor.
5.
We can have at least 1 or 2 times.
Yeah, okay. 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 Okay, very good. So we are,
Not very good at math. I think that's 19.
yeah, okay. That's fine. We'll figure it out. Maybe we need to change the setup as opposed to an L shape, because once we get the jury in here, it's going to be much more important that you all are facing the jury than me. So what I may do is have the bailiffs, we'll work on it, but maybe move the tables so they're actually facing the jury, and during jury selection, turn them so they're facing out towards the jury, something like that. Okay? So we'll make it work. We'll figure it out.
Your Honor.
Yep.
Hi, I'm Nixon Rice investigator. I have Deborah told me, she said she is available April 2nd in the afternoon at 1:30.
Okay. State.
Does that work for you?
It is for me, but I don't know, does it work for the state?
Sorry, what was that? April 2nd at 1:30.
Could we make it 2 o'clock?
Okay, for the state.
Okay.
I would say yes, like we have.
All right. So, and then as to,
I also think, just from speaking with Ms. Toomey and myself, there's one other matter that we may not be in total agreement about, the defendant's reported statement that she may want to bring to your attention. We have worked out most of it.
as to Davion Murphy.
Yes, ma'am.
Okay. That's fine. So I will hear those matters at 2 o'clock on April the 2nd. If the other defendants wish to be present for that, you're welcome to. It's up to you. Mr. Gonzalez.
Oh, nothing further, Judge, and thank you for the offer. I'm not sure we'll be attending, but.
Yeah, that's fine. So for now, I'm going to tell the sheriff's office not to transport your client, but if something changes.
That's fine, Judge, yes.
Okay, so do not transport Rashad Murphy on April 2nd in the afternoon. As to Mr. Gathright, Mr. Wise, does your client wish to be here for those motions?
I have a conflict, Your Honor. Mr. Gathwright's fine with waiving.
Okay, that's very good. So do not transport Mr. Gathright. And as to Mr. Chance, Mr. Petratus? Okay, very good. All right. Davion Murphy. Okay. And that is so that I can hear I know you just gave me the motion. I know you just gave it to me. Now I can't find it. The motion with regards to the personnel files of two of the detectives from the Jacksonville Sheriff's Office.
And in objections from the defense, if we just as a courtesy, just print out the exhibits that were provided to the state and hand deliver them to the court at some point today. The attachments that were all sent to us with this personnel file, those lawsuits and such, everything we attached to. Is there anything? Sure. Is there any objection to providing that in advance to the court for review before Thursday?
No.
Okay, and for the record, it's the state's 7th penalty phase motion for order in limine? No, that's the,
Yeah, that was the one with,
yeah, that's the one I gave you all until, gave
April 10th.
April 10th to the defense to submit any case law. Oh, okay, so it would be, we're going to, as to Davion Murphy, the motion for, would be part of the state's motion for order in limine regarding improper character evidence as to unrelated officer conduct. That's what we will hear Thursday, April 2nd at 2:00. Yeah, let's just go ahead and use in my regular courtroom for that since it's just one of the defendants. All right, so please let Ms. Toomey know, Mr. Sonardi, that I'm going to hear that motion in my regular courtroom. Okay? Okay. Is that it for today? Oh, and on the raw data, I need, how quickly do you think, how much time do you think you need for your experts to get that information over to the state's expert? A week? What are you asking for, state?
Judge, I think that as long as they get it to us within the week, I think that should give Mr. Harmon's experts the opportunity to be able to review it. I don't believe they have set Mr. Harmon's expert witness for deposition yet either, so I think that that's fine.
Judge, I probably should have not let Mr. Hernandez go, but, and I don't, because I don't know the status of the way that train is rolling, certainly I'm going to just defer to whatever the court thinks.
All right, I'm going to say by April 8th, by the time we begin jury selection. Okay?
Judge, and just that reminds me, I know that Mr. Petrinus listed an expert, a gang expert as well, that we attempted to take the deposition of, but that expert is Dr. Leap, had not actually finalized her opinion, and she said that she would have it finalized by the 8th, and we would be able to take her depo in a couple of days from that time frame. I just wanted to put that on the record just to make sure that she has her finalized opinion by that date.
Let her know, we scheduled it for April 9th at 5:30. And I let her know that. She responded, she's under the weather right now.
Okay.
Won't be a problem for April, but I did let her know that demo date, and she has
Yep.
sent me a pushback.
So that, what's the expert's name again?
Dr. Leap.
Leap? Okay, Dr. Leap's report needs to be submitted to the state by